Committee, Mr. Frank, for 3 minutes.
For how much time?
I was informed 3 minutes.
Thank you. Yeah, I'll remain time. Thank you. I speak as one of the 315 members of the House who hasn't asked you to delay this. I must say that it does seem to me that delay here was a stalking horse for opposition in the case of most people. And I'm particularly struck, in general, people who don't like regulation and who think things were actually running pretty well from the legal standpoint during the time when all the troubles were accumulating. They have said that they are really concerned about uncertainty, and they blame a lot on uncertainty. So what are they asking for now? More uncertainty. They are asking for a delay in this rule. It's in the statute. It's coming. I do not understand how you reconcile an argument that uncertainty is our major problem with a plea for more uncertainty by delaying the rule. We are also told that this is going to be putting us in international disadvantages by some. My understanding, and I hope this will be elaborated on in the testimony, is that in England, our major competitor in the financial area, they have a proposal called ring fencing. I don't know what the hell that means in England, but whatever it is, in my experience, as I've read it, more restrictive on the deposit-taking institutions than what we're proposing. And I think we do have sometimes with the financial institutions, when they talk about international regulation, they follow the model of the teenage child of divorced parents, playing mommy off against daddy, claiming that he'll let me do it and she'll let me do it. I do think, as I said, England has gone even further here. Then we're told, well, we shouldn't do anything about this because it wasn't the cause of the crisis. Well, I agree. It was not, this particular thing was not a cause of the crisis. But the notion that in adopting regulations, we should deal only with things that have already proven to be problematic and not try to anticipate, not try to make other improvements, I think is a grave error. I do think that there is a reason to do this in a very comprehensive way. And finally, there was the complexity argument. As I understand the complexity argument, you are guilty, you regulators, of trying to accommodate some of the concerns that the financial institutions had. There were people who have Glass-Steagall nostalgia. They talk about how it was 6 pages. A very simple rule could have been formulated, but it would not have accommodated the concerns that you heard from the financial institutions. So to some extent, they are complaining about your having accommodated them. The final thing, I said final, but there was one last point. And
if I could interrupt the ranking member for just a moment. I was informed wrong. You are to have 5 minutes, so you don't have to talk either A, so fast, or you don't need to wrap up so quick. So you have an additional 2 minutes.
There is the option of repeating myself, but we all take advantage of that. We all take advantage of that, and that comes with the territory. But I will talk about, and I appreciate that, Madam Chair. We're talking about complexity. One of the legitimate concerns we have heard is that market making is important because of liquidity, although I was impressed with a chapter I just read in a compilation put out by the London School of Economics by Adair Turner, the head of the Financial Services Authority, in which he makes the argument, I think, persuasively to me, that doing anything that increases liquidity, even by a very small amount, regardless of what might it mean in terms of instability, is not a good idea. There is a cost-benefit analysis that has to be applied for people who say, oh, anything that gives us more liquidity. I have bonds. I'd like them to be able to sell, but I don't think they'd have to be sold in 8 seconds for me to be satisfied. Market making is, however, a legitimate concern here. And what I'm told by some is, well, yes, we understand that the regulators say that they're going to allow market making by institutions, regardless of that the Vockler Rule will allow them to engage in market making, but we're afraid that they will over-regulate, that they will be too tough, and therefore institutions fearful of excessive rigidity and harshness, fearful of vindictive regulatory action if they come too close to the line, will pull back too far. And my question there is, in what universe have people been living in which the problem has been that financial regulators have been too tough, too harsh, too vindictive, have extracted too great a penalty for errors of misunderstanding? In fact, I think the record is very clear that our regulators, over time, both parties have, if anything, we've under-regulated and under-applied the rules. But one of the things that I will ask our witnesses is, and I think this is important, My understanding is that the regulators do appreciate the importance of market making because of the legitimate contribution it makes to liquidity. And I would think a very good thing to do, not to have uncertainty, would be to get the rule put in place in a reasonable time period, not further delaying it, and having these regulators demonstrate, in fact, what I hope they will demonstrate today rhetorically, that they appreciate the importance of market making and do not intend to enforce this rule in any way that will impinge on legitimate market making activities. Thank you, Madam Chair.
Thank you. I'd like to recognize Mr. Grimm for a minute for opening statement.
Thank you, Madam Chair. First, let me state that I disagree with my colleague on the other side of the aisle, the ranking member. I think the Vockler Rule is a terrible idea, and I think it should be repealed. Proprietary trading, as we just heard, was not a driving cause in the financial crisis, and this rule